You're watching The Legal Breakdown. So, Glenn, we've got some big news out of Florida. As we know, one of the main charges that Trump is contending with in his Florida criminal trial is obstruction. And the foundation for the obstruction charge is testimony from Trump's own attorneys. And the only reason that we have this information, this testimony, is because attorney-client privilege was pierced due to the crime-fraud exception. There's no attorney-client privilege if the privileged information was in furtherance of a crime. But now, thanks to Judge Cannon, that might be at risk. So can you speak on what's happening now?
You know, Brian, this issue was already litigated extensively and resolved, ruled on by Chief Judge Beryl Howell in Washington, D.C. So this is now like Judge Cannon sort of deciding that she didn't like the results of the last Super Bowl, so she's going to make everybody replay the game. It is absurd. So here's what happened. During the course of the grand jury investigation into Donald Trump's criminally retaining classified documents, obstructing justice, and violating our nation's espionage laws. In the grand jury in Washington, D.C., there was extensive litigation on whether Donald Trump used one of his lawyers, Evan Corcoran, in furtherance of committing crimes, obstructing justice. After this issue was litigated by a really experienced, well-regarded judge, then Chief Judge Beryl Howell, Chief Judge of Federal District Court in Washington, D.C. Judge Howell ruled absolutely Donald Trump was using his lawyer in furtherance of a crime. Therefore, Donald Trump can't claim that the prosecutors can't find out what he and his lawyer were talking about, because if you're using your lawyer to commit crimes, guess what? You can't claim the attorney-client privilege to try to prevent prosecutors from finding out what you were telling your lawyer to do criminally on your behalf. So Judge Beryl Howell ruled that the crime-fraud exception basically pierces or extinguishes the attorney-client privilege, and she ordered Attorney Evan Corcoran to go into the grand jury and testify about, in a very real sense, testify against his client, Donald Trump. Settled. The legal issue was resolved. Well, now Donald Trump said, you know what? I want a second bite of the apple. And he filed a motion urging Judge Cannon, who was a Trump-appointed judge who has been showing extreme favoritism to Donald Trump all along, and who has abused her judicial discretion in favor of Donald Trump, according to an appeals court. He said, I want you to relitigate this issue. And for some reason, she said, I'm happy to do that. And she issued an 11-page ruling and order. And let me tell you, I've got it right here, Brian, and it's not worth anything if you read through it. There's almost no case law in there, but buried on page 7, there's a little glimpse of what's motivating and driving Judge Aileen Cannon. She actually says to Jack Smith, well, you know what? You haven't come up with any case that says I can't do this. Now, she doesn't assert that there's any case law that says she should or is required to do it, but she said to Jack Smith, you haven't provided me any authority, any precedent, any case law that says I can't do it, so you can't stop me. Well, the reality is Jack Smith can stop her, or at least he can try by filing a motion to have her removed because her impartiality might reasonably be questioned. You know, coincidentally, I just authored a piece for MSNBC. I'm not here to hawk my piece, but the title of it, and the reason I'm referencing it, is because Judge Cannon just sort of proved me to be right. The title is The Unmistakable Evidence That Judge Cannon is Unfit for Trump's Classified Documents Case. And there she goes again. She just proved it with this new ruling.
And by the way, for those watching right now, if you want to be able to read that MSNBC piece, I'll link it right here on the screen and also in the post description of this video. Highly recommend. It's a very good read. Glenn, that actually leads to the question I was getting at here, which is if Judge Cannon ultimately does do away with this ruling by Judge Howell, will that finally be enough of a predicate for Jack Smith to seek her removal? And I ask because not that we don't know that there are already plenty of justifications for her to do so, but will it be big enough relative to the other stuff that apparently wasn't big enough? And I'm talking about her being rebuked by the 11th Circuit right at the very beginning, her putting forward these bogus Presidential Records Act jury instructions, her listening to two other judges on the same in the same court system that were telling her that she shouldn't take this case, her refusing to schedule an August 12th trial date, which was the request made by the Trump team. Like, all of these were apparently not big enough unto themselves for Jack Smith to seek removal. Will something like this, I mean, basically laying the foundation to eliminate the entirety of the obstruction charge that was already adjudicated by a perfectly capable judge, will that be enough?
I would say it would be the cherry on top of the disqualification Sunday, and it absolutely should be enough. At some point, when a judge is showing such bias, such favoritism toward one party or another, particularly when that party, Donald Trump, is the person that you owe your job to, your lifetime appointment as a federal judge, because it was Donald Trump who appointed her to the federal bench. At some point, enough has got to be enough. And I think if she abuses her discretion once again and basically overrules Chief Judge Beryl Howell, who is 1,000 times more experienced and, frankly, far more highly regarded than Judge Aileen Cannon, I would think that's got to be the last straw, and that would probably prompt Jack Smith to finally file the motion to recuse.
Well, let me ask it this way: does this feel like it's in a different category than those other incidents?
This motion is far more dramatic than some of the other frivolous motions she has been litigating ad nauseum. Loose translation from the Latin, the whole damn thing is making us sick, right? And she continues to litigate these frivolous motions, all the while, Brian, refusing to set a trial date. And the thing that our viewers probably know, because I think we've talked about this before, the reason you set a trial date, that's what federal judges do. They set trial dates. Then they set a whole bunch of intermediate deadlines for discovery, for the filing of motions, for the arguing of motions, for the resolution of motions. All of those deadlines are dependent on a firm trial date. She won't even set the dang trial date, so she sets no intermediate deadlines whatsoever. This case could linger for years, given the way Judge Cannon has been approaching it.
Glenn, does she have anything else on her docket? Like, does she have a case after the Trump classified documents case that's just languishing for years behind this thing? That's one question. And the second is there like a quota that judges have to fill, or can they just sit on the bench and allow one case to languish for years and years and years if they want to, and then they just get paid for basically not doing their jobs?
So on the one hand, each federal judge is considered an equal among equals, and they have almost complete autonomy. Now, the chief judge in the jurisdiction, Chief Altanaga, who, mind you, is one of the two judges, according to the New York Times reporting, that urged her not to preside over Donald Trump's case, and she bucked the judge. She ignored the judge's advice. The chief judge of a jurisdiction will set basically benchmarks and guidelines, and the chief judge is generally responsible for equally distributing or seeing that cases are equally distributed among judges. They set certain goals. They like to have cases resolved in X number of months, but there are more exceptions than there are rules because every case is unique. Some are very big and long and take a long time to wind their way through the system, and some can be handled relatively quickly. But I don't know what Judge Cannon's caseload looks like, but I'm certain she has other cases apart from the Trump case. Of course, if you remember some of the reporting about her relatively short time on the bench and how she screwed up other cases on some of the basics, like swearing in a jury at the proper time. I mean, really judging 101 that she seemed to fail previously. And I think she's only had a total of about 3 or 4 trials as a judge. And the fact that she now has one of the most consequential cases in our nation's history and is badly mismanaging it, whether intentionally or just negligently, grossly negligently, is still an open question, perhaps. But, she's the wrong person at the wrong time on the wrong case. And why in the world the people shouldn't have a fair, independent, impartial judge? Heck, that judge can be appointed by a Republican president. That's not the point. The American people deserve to have this case tried in a fair and timely manner. And right now, our rights are not being honored.
Let's finish off with this, just for posterity here. To the point of everything you just said, how did it end up that Judge Cannon actually got this case, if even the chief judge in her own circuit was basically suggesting that she don't take it?
The way she should have come into the assignment is that she was the next judge up on the wheel. That's what we call it. You know, if you picture a big wheel with the judges' names on the wheel, when a judge gets a case assigned to him or her, the wheel is supposed to tick one click, and the next judge who's up is supposed to get the assignment. That's the way it was supposed to work. I am not a conspiracy theorist, Brian, although I've prosecuted enough conspiracy cases that I can tell you there are lots of criminal conspiracies out there. So I am going to assume that the court system in Florida followed the normal procedure. She was the next one up on the wheel, and when the case came in, it was assigned to her. I hope there was nothing nefarious at play with the assignment up front. But, you know, when you see two of the federal judges in that very jurisdiction in Florida, the reporting shows, went to her and said, don't accept the case. Do not preside over the Trump case. Why? Well, inferentially, because the 11th Circuit Court of Appeals has already found that you abused your discretion and did something the law does not allow to the extreme benefit of Donald Trump. You interfered in a DOJ investigation into the crimes he was suspected of having committed. I mean, if that's not reason enough from jump to decline to accept that appointment to that case, I don't know what is.
And finally, when can we expect a resolution to this question as to whether or not she's going to seek to drop this obstruction charge by relitigating it?
You know, she has been litigating largely frivolous motions for months now, and she rarely even issues rulings denying or granting the motions. She just continues to build the logjam of motions, and it seems like the case will never move downstream in the direction of a trial. So I have absolutely no answer about when she will hear this case, how lengthy the evidentiary hearings will be. And then once they're over, she's also been in the habit recently of saying, well, now if you're interested in filing supplemental briefs, now that we've argued it, why don't you go ahead and do that sometime in the future? When she'll actually rule, anybody's guess.
All right. Well, with that said, we will stay on top of this as soon as we have any update on this specific question, because, you know, to the point that you made earlier, this is absolutely a big one and could hopefully be enough grounds for Jack Smith to finally, you know, to finally move forward with some type of motion to have her removed, because she shouldn't be on this case in the first place. With that said, for those watching, if you want to stay on top of all this stuff, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.